Litigation takes years to resolve. During that time, physical or financial assets at the center of a dispute sit in a state of high vulnerability. Securing legal title to an apartment building is a hollow victory if the property falls into disrepair or if a hostile occupant drains its rental income before the judge ever issues a ruling. Courts deploy provisional remedies to bridge this gap. These are temporary legal mechanisms designed to secure the status quo while the main lawsuit grinds forward. Rule 59 of the Rules of Civil Procedure engineers a specific provisional remedy known as receivership. It legally extracts the disputed property from the warring parties and places it into a strict court-mandated holding pattern. Appointing a receiver does not determine who rightfully owns the property. It merely pauses the destruction. Rule 59 acts as the court's emergency brake. It ensures that the final judgment, when it finally arrives, can actually be enforced in reality, rather than existing as a worthless illusion on paper. Because seizing property from a current possessor is an aggressive intervention, courts do not activate this emergency brake lightly. The mechanical requirements to trigger a receivership are precise. An application for a receiver can be filed in the trial court where the main action is pending, but the power to appoint also extends upward to the Court of Appeals, the Supreme Court, or a member of those appellate courts. To justify the appointment, the applicant must prove their situation fits strictly into one of 4 exclusive grounds, mapped out by the DFAO framework. The D stands for danger. The applicant must show a clear interest in the property and prove that the asset is in imminent danger of being lost, removed, or materially injured unless a receiver steps in to preserve it. The F is for foreclosure of a mortgage. This applies when the property is in danger of being wasted, and crucially, its value is probably insufficient to cover the outstanding mortgage debt, or the parties explicitly stipulated to a receiver in their contract. A activates after judgment. This allows a receiver to preserve the property during a pending appeal, or to aid execution when the losing party refuses to apply their property to satisfy the judgment. Finally, O covers other cases, where the court determines receivership is the most convenient and feasible means of preserving the litigated property. To prevent frivolous deployment of these triggers, the initial application must be verified, sworn under oath by the applicant. The court also demands actual proof of imminent peril. A mere suspicion that the opposing party might mismanage the asset fails the legal standard. The strict DFAO triggers act as a rigorous filter. They prevent receivership from being weaponized as a standard tactical maneuver, reserving the remedy exclusively for genuine preservation crises. Even when a DFAO trigger is met, the process requires strict financial safety valves. Provisional seizure requires the applicant to have skin in the game. This financial accountability is enforced through a highly structured bond ecosystem. The first financial barrier is the applicant's bond. We define this using the mnemonic BAD, the bond of the applicant for damages. Before the court even issues the order appointing the receiver, the applicant must post this bond. It operates as a direct insurance policy for the adverse party. If the court later determines that the applicant procured the receivership without sufficient cause, this bond pays for any operational or financial damages the adverse party suffered due to the interference. Conversely, the party currently holding the property has a built-in defense mechanism to stop the seizure. By filing a counterbond, they can discharge or deny the receiver, hence the mnemonic CBD. The adverse party posts their own financial guarantee, asserting that their bond will cover any damages the applicant might suffer if the current possessor retains control. Together, the BAD and CBD bonds mathematically monetize the risk of provisional remedies. Neither party can inflict operational disruption or property degradation with guaranteed upfront financial accountability. If the adverse party declines to post a counterbond, the court will proceed with appointing a third-party manager. A receiver is strictly an impartial, neutral officer of the court. They do not act as an agent, employee, or advocate for the applicant who requested them. To enforce this neutrality, we encounter the third tier of the financial system, the receiver's oath and bond, or ROB. Before touching a single asset or collecting a single peso of rent, the receiver must swear an oath and post their own bond. This guarantees they will faithfully discharge their duties, obey court orders, and refrain from embezzling the estate's funds. Across all 3 of these bonds, a universal procedural rule demands total transparency. summarized as SID. The filer must serve copies of the bond to all interested parties. If a bond is backed by weak sureties and found insufficient, it leads immediately to denial of the application, discharge of the receiver, or default back to the receiver's appointment if the counterbond fails. The combination of strict ROB constraints and SID transparency strips the receiver of any partisan bias, transforming them into a transparent, fully bonded extension of judicial power. Once appointed and bonded, the receiver assumes operational control, but their authority is strictly limited to preservation, not unilateral exploitation. The general powers granted to a receiver map out to the mnemonic PRICES. All of these operate within a strict perimeter, requiring judicial oversight. The routine preservation powers allow the receiver to possess the property, receive rents and pay outstanding debts, compromise and collect debts owed to the estate, and execute transfers or divide property as authorized. However, the letter I introduces a major legal trap: the power to invest funds. A receiver cannot unilaterally invest idle funds, no matter how profitable the opportunity appears. Investing requires both a specific court order and the explicit written consent of all litigating parties. The final letter, S, represents the second major trap: the power to sue or be sued. Engaging in collateral litigation is forbidden. A receiver cannot file an eviction suit against a tenant, nor can a third party sue the receiver, unless they first obtain explicit leave, meaning permission, from the appointing court. Operating within these constraints requires physical access, which leads to the question of how the court protects the receiver from hostile, uncooperative possessors. The law imposes a strict obligation on any person holding the property, ledgers, or keys to hand them over upon the receiver's reasonable demand. When a party defies this obligation, the court relies on the enforcement mechanism of CRD, contempt for refusal to deliver. A stubborn refusal to surrender the assets results in judicial contempt, bringing fines or jail time. Furthermore, the uncooperative party becomes directly liable for the value of the property and any financial damages caused by their delay. The receiver operates within a highly guarded perimeter. They possess immense power to manage routine upkeep, but remain strictly restrained from altering the asset's financial nature or engaging in outside battles without judicial oversight. Litigation eventually concludes. Once the main lawsuit is resolved, or the initial danger to the property has passed, the necessity for the receiver ends. Receivership is strictly a temporary state. The court will terminate the assignment either motu proprio, on its own initiative, or upon the motion of either party. Ultimately, the winding down process follows the SDC termination protocol. The court will first settle the receiver's accounts to ensure no funds are missing. Next, it directs the receiver to deliver the property and remaining funds to the legally entitled winner. Finally, the court will compensate the receiver for their services, with these fees typically taxed as costs against the defeated party in the lawsuit. The SDC protocol ensures a clean, thoroughly audited handover, safely returning the property from the court's jurisdiction back into the private sphere. This leaves one final procedural question. If a party suffered actual, measurable business damages during the receivership, how do they claim financial recovery against the BAD, CBD, or ROB bonds? Injured claimants cannot simply file a brand new independent lawsuit against the surety company that backed the bond. Instead, the process is governed by the RABS 57 rule. Recovery against bond sureties follows Rule 57. Any claim for damages against these bonds must be formally applied for, ascertained, and granted strictly within the exact same trial proceeding. The claimant faces an absolute deadline. The application for damages, along with notice to the surety company, must be completed before the trial court's final judgment becomes executory. Rule 59 operates as a perfectly closed procedural loop. From the strict DFAO triggers at the beginning to the Rule 57 recovery at the end, it ultimately guarantees that the extraordinary power to seize assets never escapes strict judicial oversight and financial accountability.